preparing the argument. If you are preparing the argument with regard to the issue wise, so you have to prepare the argument with regard to, yes, this is the issue, this is the point, this is the question, this is the answer, this is my defense, this is the answer. That's all. So that's why for this, you have to show from your written statement, this is the defense you have taken in the written statement, that the plaintiff, being the contractor, has not executed the, not used the explosive for the hard rock, in spite of the permission given by the defendant, and in the cross examination show that you have taken the defense in the cross examination. Then only you can say that the defendant has proved the case, and they have not proved the, they failed to prove the case. They have not executed the work in spite of the permission given by the plaintiff, defendant.
This answer, my lord, I will give in the next date, my lord. And before that, let me, my lord, please. My lord, then, my lord, I come to issue number 3. Whether the designs, drawings, and work methodology approved by the defendant number 2 on the basis of subsoil exploration report and GAD made over by the defendant number 2 ultimately frustrate the contract and render it impossible of performance. This is the issue number 3, my lord. And the answer is, my lord, the as you also got it, issue number 3. The designs, drawings, and work methodology, that is the GAD, the General Agreement Design.
Yes, got it.
My lord, based on subsoil exploration report of Vision Labs, Hyderabad, handed over to the representative of the plaintiff number 1, was perfectly correct, and as per the technical requirement of the.
Where from you are reading?
My lord, I will place.
You are not. Okay.
My lord. Now, my lord, the subsoil exploration report, exhibit 2. Kindly have a look, my lord.
Yes.
My lord, this exhibit 2 and DD 12 pages 367 to 411 was prepared by the Vision Labs, a very reputed, my lord, firm of, my lord, and then one reputed laboratory based at Hyderabad. The said Vision Labs had thoroughly made survey and soil testing of the proposed location of the bridge. In the said subsoil exploration report, a bar chart has been appended wherein abutment 1 and pier 1 to pier 7 hard rock has been clearly shown. My lord, kindly have a look, my lord, in the chart, my lord, that in the vision report, the report, my lord, this is chart is given, my lord, at page number. My lord, here this is given, my lord.
Which page? Which page of the report? Chart?
My lord, this is, my lord, the my lord, exhibit 2. Exhibit 2 and running page, my lord, this is the chart is given, and then, my lord, bar chart is there, my lord. Should I? My lord, here, my lord, kindly have a look, my lord. And before that, my lord, if I place the 6.6 core recovery and RQD data of rock cores at a glance, that is before that. Before, my lord, about 8-10 pages before that, there is a chart. This 6.6 core recovery. They are given details of that after how many meters digging the hard rock is will be found. That chart is given here, itself. Kindly have a look, 6.6 core recovery and RQD data of rock cores at a glance.
Where from you are reading?
This is, I am reading from the report of the Vision Lab.
Which page?
Have you got extra copy?
Which page of the report?
This is the, may I hand up? The chart. So here, 6.6 core recovery.
Yes, 6.6.
Yes, my lord. So here, I want to place before your lordship that this data, this is prepared by the Vision Lab. Here, what the Vision Lab has said, 6.6 core recovery and RQD data of rock cores at glance. 4 whole number. Abutment 1, depth from 10.75 to 11.50. Then strata, black cold soft. So it is mentioned here in the report itself that there is, after this there is a black cold. And then, 11.50 to 20 meters, black coal hard, mentioned there. Then, I come to Pier 1. This is abutment 1, and then Pier 1. Pier 1, 9.20 to 10.75, black coal soft. Then 10.75 to 19.25, black coal hard. And then Pier 2, 6.00 to 6.50, black coal soft. 6.50 to 14.50, black coal hard. Then, like this, in all the piers, after certain level, there is hard coal. Hard coal is mentioned in the report itself. Now, the chart which I mentioned before, lordship, that is the bar chart. Here the figure given, then bar chart shown that after.
So when this report was handed over to the contractor?
This was handed over in August 2010.
Before commencement? After commencement?
After the letter of acceptance. After the letter of acceptance. Letter of acceptance in July 2010. It is handed over after a month when the representative of the plaintiff visited to the office of the defendant number 2. It was handed over.
So this one?
In this report.
Okay.
This report mentioned. And on the basis of this report, it was requested that to expedite the work, but it was not restrained that you don't get your report yourself done. But it was stated that you get it expedited. I have already a report, because this is mandatory report, because the railway board has mandated that before granting any tender.
So with regard to the hard rock, what is the rate prescribed in the contract? If you before the award letter, you are having the soil report, correct? So if the soil report, the contract which you have published, the tender which you have published in terms of the preliminary report, preliminary estimation of your plant department or architect department, whatever it is the railway says, It is the preliminary on the basis of the preliminary report. Subsequently, you have published the tender and the tender was awarded, contractor was awarded. And after that, soil exploration report has been handed over. In the soil exploration report, there is a hard rock. You find the hard rock, hard coal, and all the things are there. In the contract, is there any provision with regard to the price escalation of the hard rock and the soft rock?
My lord, the tender.
You will not escape from this court.
In first and second tender, no provision in the BOQ. In the third tender, where our suggestion was for the piling, in that they have put provision for hard rock. That is our case. That ultimately you are touching the nose, but not like this. From first and second tender, no provision. It's as simple as that, as if there is nothing.
That's what I'm telling. If the
no provision.
Provision.
And the third tender is an escalation of 250% of the first value.
Naturally, because hard rock, it is not a simple thing.
And that to not for the entire thing. I have done 80%. For 20% work, balance work, 250% escalation. That's the natural part.
Milord, that is not so, Milord.
I am not accepting. Milord. See, Mr. Drolia, with regard to use of explosive for the work is to be done in the hard rock. Normally, even either the airport authority or the railway authority or any authority, they never gives the hard rock price. Once they came to know, once the contractor started putting the bill of the hard rock, then dispute starts. And what you have shown with regard to the explosive, use of explosive is not simple as you have stated in the agreement. There are a procedural. How the explosive is not simple. You take this and for the explosive, what are the things is to be used, for the explosion of the hard rock?
Permission is required from the authority.
No, permission is different. What the things is to be used? That is a gelatin. And gelatin contains the stick. And is that stick having the full of what explosive items? And you have to take very care. And it is not the executive engineer. There is a permission limit of the executive engineer to issue the gelatins for one time. And that also, it is not that the explosion is to be done in the public area.
It's a highly dense area.
The fully public area,
it is the river bed, Milord, not dense area. It is
not. I am not telling. I am regarding the procedure of the explosive.
Milord.
The dense, the populated area cannot be
used.
So you might have been visited the quarry and these mines.
Milord, coal mines.
That is the thing.
So here, Milord, when the tender was issued, then in the tender, Milord, itself, the terms and conditions mentioned there. And they also mentioned there, if there is any blockade by any means, then use of explosive provisions has been made. So therefore, Milord, even if the rate has not been provided for use of explosive, so that, Milord, that is the choice of the contractor to accept tender or not.
That's why I'm asking a specific question to you,
Milord.
With regard to this report.
Milord.
Was before the order, before the award, or prior to award? If before the award, how the contractor can say, I will not accept your tender amount if the hard rock is not there? And subsequently, you have given the report. If you have given the report and you showing that it is admitted there is a hard rock and a hard coal, automatically acceleration will come. That all the things you have to work. Yes, continue.
Milord. Milord, this, Milord, subsoil exploration report was prepared by the Vision Labs, one of the reputed laboratory at Hyderabad. The said Vision Labs had thoroughly made survey and soil testing of the proposed location of the bridge. In the said soil exploration report, a bar chart has been appended wherein abatement 1 and Pier 1 to Pier 7 hard rock has been clearly shown. The subsoil report was prepared and signed by the persons having expertise and necessary qualification for survey and soil testing to carry out the big projects. The said subsoil report was signed by Sri K. Kastwari Nath, MTech, IIT Madras, consulting geologist engineer, and Sri K. Keswarao, MSc Tech, senior geologist. So here very senior that experts who had given this report, because report is under challenge. Because report is under challenge by my learned friend, that report has been procured, not reflecting the correct
So
picture.
if the report is under challenge,
Well, yes.
you are not examining the expert here.
Challenge means they are disputing the report.
Correct.
Huh.
If one thing is in disputed, it is the duty of the other side to prove it and prove it. See, mere exhibiting the document cannot say it is admitted. It is proved. If other party has denied with regard to this report, so you have to prove it. Correct. How it has to be proved? You have to bring any of the either the Keshavrao or he has to bring on doc.
Nath. Yes.
He has to bring on doc. You're not examining the person. You're not examining the person. How you be able to justify this report? You're not the scientist. You're not the expert. The court is not an expert.
Well, I handed over this report to the plaintiffs, and now this is up to the plaintiffs to accept this or have it a separate investigation of own. Because there, my lord, the acceptance, my lord, the contract, the letter of acceptance communicated, and thereafter, after 1 month, it was when visited, then handed. By that time, nothing happened. By that time, he could have availed of this, if at all wanted his separate investigation, but did not. They took this and relied on this.
Okay.
Then, my lord, after getting the subsoil exploration report from the defendant number 3, defendant did not raise any question regarding authenticity, methodology suggested in the said report. On the contrary, the plaintiff by letter dated 4/5/2012, Exhibit 5, from the plaintiff number 1 to the defendant number 3, sought permission for use of explosive for blasting in sinking of wells in hard strata. Then, my lord, the plaintiffs prepared the designs and drawings based on the subsoil exploration report of Vision Labs and submitted the same to the defendant number 2 for approval. Defendant number 2 approved the said designs and drawings with certain modification. In this regard, the chief bridge engineer, South East Central Railway, Bilaspur, wide it letter dated 31/1/2001, Exhibit 3, provided 2 major instructions to the plaintiff in execution of the said project. Kindly have a look, my lord, the Exhibit 3.
Give the Exhibit 3.
As you also got it.
Yes, yes.
My lord, here, my lord, the A, all necessary arrangement to penetrate the wells in hard rock should be made prior to the fabrication of well curves. B. It was further instructed that initially only one well should be lowered completely in the ground. So after success of the sinking of one well completely, the task of sinking of other well will be easier. The aforesaid facts have been confirmed by the witness of the plaintiff. Now, my lord, here see that this is the letter, exhibit, my lord, 3. In this letter itself, my lord, this is communicated to the contractor that look here, that since the depth of the rock is up to 10 meters, which will be tough job. Mentioned here, all necessary arrangement for lowering the well up to 10 meter in hard rock must be ensured. After some depth, there will be hard rock. It is stated there. And to be ensured before fabrication of well cups, and after successfully lowering one well, further fabrication of other well cups should be initiated to avoid any future complications. So therefore, my lord, this is clearly stated by this letter sanctioning the designs, and my lord, this designs and drawings. And my lord, while accepting this design and drawings, my lord, this conditions was made that only one well should be first should touch, so that if there will be any problem, then that should be sorted out. And there, my lord, that and no lifting of well base will occur as well incur in the soft rock. Passive reaction force lifting one edge from the rock mass in contact will restrict lifting. So here, my lord, this instruction was given, and the bar chart is annexed, that after how many meters in down, my lord, there will be the hard rock. So therefore, there should be the proper arrangement be made prior to starting the work. This is the instruction communicated, my lord, through the chief engineer to the contractor. And this is, my lord, exhibit 3.
Yes.
Now, in this respect, my lord, the aforesaid facts have been confirmed by the witnesses of the plaintiffs as well as the defendants. Railway. Question number 85 to 91 of the plaintiff witness number 2. Question number 85, below the plaintiff witness number 2.
What is the name?
Name of the witness is, my lord, the Pradeep Kumar Mukherjee.
Page, question number?
My lord, 85. My lord, here, my lord, in 85, shown a letter dated 31st January 2011. And then, my lord, kindly tell, is it the letter approving the structural designs of abutment and pier of bridge number 182, span 9 into 45.7 meter between Ib, Jharsuguda, in connection to third line between Chapa and Jharsuguda? Answer is, my lord, is it the approval letter after submitting your design to the railway for the construction of the bridge? Yes, this is the approval letter, but this is the internal correspondence from the chief bridge engineer to the chief engineer construction. This is not this is internal, but this is communicated to the chief engineer to the contractor. instruction was conveyed to the contractor.
Yes.
Then my lord 86. But this is the plaintiff's document. Yes, a copy of this letter was served. Then my lord kindly see 87. Kindly see last paragraph of this letter and tell what has been stated therein. Yes, since the depth of the penetration rock is up to 10 meters, which will be tough job, all necessary arrangement for lowering of well up to 10 meter in hard rock must be ensured before fabrication of well cups, and after successfully lowering one well, further fabrication of other well cup should be initiated to avoid future complication. So it is clear that there is a clear direction in this approval letter that the plaintiff should start the job in one well, and after successfully lowering one well, further fabrication of other well cups should be initiated to avoid future complication. Right. But this directive is to the chief engineer, not to the plaintiff. This is not correct. Letter is internal. Chief bridge engineer writing chief engineer, but chief engineer this conveying to the fact this letter to the contractor.
Where is that?
You know that
Where is the letter to the contractor? Yes, this has been approved, and you have to adhere with the condition laid down in the letter dated 31st January. Where is that?
Well, yes, this letter, my lord, subsequently by a forwarding letter of the chief engineer, my lord, given to the the contractor. Then, my lord, witness number 2.
I don't think there is any forwarding letter, Milan.
Correct.
He has to
Kindly-
prove that there is a forwarding letter.
Kindly come to
Forwarding letter.
kindly come to this letter. The exhibit 3 you are having.
My lord, here to the PD8 and exhibit 3.
Exhibit 3 is the same.
Yes.
Same.
And this exhibit 3, this letter has been communicated to the my lord.
Where? Show me.
My lord, yes. Communication. My lord, this letter has been disclosed by the plaintiffs. Plaintiffs has disclosed this.
That's correct.
My lord.
Kindly come to the letter you are having the copy.
My lord.
And kindly come to the first page.
Yes, my lord.
The left hand side, first page, left hand side, pen written. Through pen. In that.
Oh, yes.
This one.
Yes, my lord.
Correct.
Yes, please give a copy of.
Please, this may be advised to the contractual agency and be kept in view with while execution. Who has signed? Signature is of chief bridge engineer. To whom? To the deputy chief engineer. Deputy chief engineer.
Yes.
Deputy chief engineer. Then deputy chief engineer, please give a copy to
Compensation.
Compensation and what is I don't know.
All the instructions.
And get all the instruction
Contained
contained to be strictly complied.
complied.
To whom? Executive engineer, assistant engineer, AEN.
My lord.
Correct. Where is that? It may be conveyed to the this. It has been forwarded to the plaintiff.
Condition is strictly complied.
Strictly
complied. A copy saying to the contractor.
Where?
Because unless it is saying, contractor would have not a copy.
Maybe, but it is where the letter. See, it is your internal.
My lord.
In the contract procedure, what is the contract? A main contract entered. All the terms and conditions, special contract, all is in the contract. If other than the contract, if wanted to rely with the contract document, that has to be in between the parties, that is the contractor and the agents and the government. So this is in between you. That's why the plaintiff is evidence is correctly, rightly, but this directive is to the chief engineer, not to the plaintiff. So where is the letter or communication made by either executive engineer or the assistant engineer or chief bridge engineer has communicated to the plaintiff for a proper execution of this work as per this approval? Where is that?
So this is, whatever there, that is there.
That's why while conducting the case, while examining the witness, all the thing has to be taken into consideration. Though this a plaintiff has exhibited on the negative side. You have approved in your internal, but has not been communicated to the plaintiff.
This should have been in that witness.
That is the case made out.
Yes, cross examination.
And where is the cross examination? This was communicated to the contractor. Where is the cross examination?
Then, my lord, this is the next, my lord.
Kindly see paragraph 427, next page of the same document. This is the reason for disclosing
427
of same document. 31 January na?
No, only 2 pages are there. You are having so many pages, this exhibit is having.
But here bar chart is there, my lord.
There's nothing.
Bar chart is there.
There's nothing.
We have been disclosed, Miller, where this letter consists of 3 pages.
But here only
412, 413, 414 and the bar chart at 415. But I don't think Myler's document, Myler is saying 2 page. Kindly similar, this is their disclosure.
No. Where is the exhibit 3? Where from it has come? Exhibit 3?
This is their disclosure to us. And this is the forwarding letter we have. Kindly see, Miller, the next page. Done.
It is not here.
Letter, this page is missing in Myler's document.
It's not there.
This is their letter they have given to us. This is their compilation. And this is the forwarding letter.
No, the exhibit 3 by which witness it was exhibited?
By the defendants.
Defendant witness.
Exhibit 3.
Yes.
Which question? So exhibit 3 the defendant witness.
Defendant witness.
So defendant, how you are telling the plaintiff has produced this?
My lord, plaintiff did not disclose the document.
That's right.
My lord, plaintiff.
Okay, show me where is the question of exhibiting the document? exhibit 3 कौन सा डेट में हुआ?
Exhibit 3. No.
3rd July.
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 Yes. My lord, here the question number 57. Question number 55 onward, my lord. I am showing you the witness 1 of the defendant.
DD 13.
No, DD?
DD 13.
This is DD.
Yeah, DD 13. Yes.
DD 13 at page 412 to 415.
Right. Kindly see.
My lord, here the question, my lord. This witness.
No. I am putting 412 to 415. So 412, 413, 414, 415, 4 pages. Correct. But this is exhibit only 2 pages. PD8 देखो PD8
PD8 what is this? Wait.
PD8 26.
You have 4 pages.
We have 2 pages. They have disclosed to us 4 pages. This is our PD8.
correct, that's why PD8 2 pages, PD13 4 pages.
But their pages, there is 4 pages.
You are not bringing the other document.
So, my lord, the purpose was to place this document wherein the direction instruction of the chief bridge engineer given to carry out the work to the contractor through the chief engineer. So that letter has been, my lord, placed before lordship on record by putting in exhibit, lord. And here, my lord, the question, my lord, relating to that question, my lord.
Kindly come to the page 50, question 56 of the PW2.
56.
Yes.
DW, my lord.
Aparvit Kirgita.
Yes, yes. My lord, kindly tell whether the, yes, 55. 55.
56, 56.
Kindly tell whether the approval letter 31st January 2011 from the chief bridge engineer South East Central Railway Bilaspur was communicated to the plaintiffs. Yes, this approval letter from chief bridge engineer was communicated to the plaintiffs by the defendant number 3 in his letter dated 8th February 2011.
Where is that letter? 8 February 2011.
8 February. What was it? Did he? It's closed.
X3 निकालो. X3. You're not ready with Mr. Drolia. After 1 month you have come. All the things are on record. You're not ready with all these things.
Milord, here, Milord, that this letter is whatever, Milord, that in record, Milord, I am placing that. Milord.
What record? All the things you have not gone through the evidence.
This letter is, Milord, this is DD document. DD document at page 366. From the deputy chief engineer to the Rahi.
Yes.
So this was communicated by this letter, Milord. This is here. Disclosed by the defendant's documents.
Yes, next.
Next, Milord.
इसको रखो फिर घूम जाए. Yes, next.
Milord, the plaintiff, then Milord, here the question number 65 and 66 of the defendant witness, Milord. In this regard, Milord, defendant witness, the question number 65 and 66, Milord, I will place before lordship.
Of who? PW?
Milord, DW1.
Yes.
Six, 65 and 65 and 66. Yeah, my lord. 65. Kindly tell, has you got it? My lord, 65. Kindly tell before this court what were the instructions provided by the chief bridge engineer in his letter dated 31st January 2011. Answer, my lord. Primarily, two major instructions were provided by the chief bridge engineer. First of which was that since the depth of penetration of well in hard rock is up to 10 meters, as per submitted drawing show, all necessary arrangement to penetrate the well in hard rock should be made prior to fabrication of well curb. Second instruction provided by the chief bridge engineer was that initially only one well should be lowered completely in the ground. This was the instruction. Then 66, my lord, kindly tell before this court why the instruction was provided for sinking one well initially, because the depth of penetration in hard rock was up to 10 meters for various wells, so it is tough job. So it was instructed that one well should be lowered completely in a reasonable time so that problems of repetitive nature which arise can be planned and suitably tackled in further lowering, so that in totality the works proceed at a smooth space. So this is the, my lord, the cross examination of the, my lord, defendant witness. The plaintiff did not follow the said instruction, which resulted their failure to complete the project successfully, even after extending the completion period till 31st of March 2014. As a result thereof,
How much time you will take further?
1 hour at least.
My lord, one thing to clarify, just. My lord, he has shown, my lord, question number 65 of my lord Mr. Khunteta. Kindly see, my lord, question number 60 to 64. My lord, this letter of 8th of February was kept, my lord, marked for identification, which was never been proved subsequently by Mr. Ekka, who come. I have just checked his, my lord, deposition. This letter is not included there.
Yes, X3.
Yes, X3 has never been proved.
X3.
So it remained as, because it was a copy and it was remain. He could not. He said that I do not know how it was sent and everything. 60 to 64. He has read from 65, 60 to 64. So I doubt whether he can rely upon this letter.
It is marked exhibit. What
Does it-
happened at that time?
X
In
for
the-
identification.
It's never proved.
X for identification.
This was, my lord, considered, thoroughly considered, then it has been marked exhibit. Your lordship will not mark anything.
Your officer sitting in the higher post is not able to come to the court to prove the case. The court can prove the case. Neither your deputy chief engineer nor the chief engineer has come before this court. You have sent the chargement of your from Jharkhand to depose on behalf of the chief engineer. Not to allow this court to open the mouth. I know how the officers work. They do all the mischief. When it is come in the head of the department, they will go and the fourth class of persons will be sent to the court. What prompted the chief engineer or executive engineer or assistant engineer to come to this court? All the documents has been marked as the X for identification, and you have bring the one of the draftsman or what some chainman has been brought before this court instead of the executive engineer or chief engineer. There are very big person to not to come to the court to depose the case on behalf of the authorities. And when you will lose the matter, then it will be put up upon your shoulder. Advocate has not done the matter properly. If you are the Union of India advocate, you should be strict, sir. Otherwise, you will be blamed. All documents have been X for identification.
My lord, here, my lord, there were certain documents for identification, and those
For
were
this document,
cleared
leave aside other.
subsequently.
For this document,
My lord,
X3 is not identified. They have denied. What is the duty of the defendant?
My lord, this was for verification of the signature.
No.
Expert identification. What is the expert identification? Come,
Existence and
give
both
the evidence act. Why the expert identification? Why the exhibit? Why for identification? That is the problem I find in the original side. Nobody is following with the evidence act. Case filed, one witness examined, okay, proved. All document brought on record, proved. Expert identification not proved, sir.
Yes, it is subject to the
Subject to prove. So how will prove? Either the author.
And my lord, the document was merely to prove the signature of the author.
No.
Existence and both
Existence and the contents.
both were denied by her.
How the contents will be proved?
My learned friend is annexing this document in their.
They may annex.
documents.
They may
And now they
annex.
are
No,
denying.
this is not our document, sir.
This is disclosed by the plaintiff.
That's correct. That is a matter of argument. I am telling you. I am telling you whether they have relied or not relied, because see, Mr. Drolia, there is a procedure at the time of evidence. It might be he has having the document. Suppose, leave aside this all big matter. Come to the specific performance of contract. You are the plaintiff. You relied upon the agreement. Defendant has sold the property to you, but defendant has not come forward. He is having the copy. Whose duty to prove? Who is relying upon the document? He might be having the copy. Whose duty to prove the document?
Person relying.
Then
Tomorrow, my lord.
tomorrow kal hai?
Yes,
come tomorrow.
Just
Come
my lord, only one question was put by your lordship to Mr. Ekka, that whether these authors are still in service. He said yes.
That's why, I know. I was that side and I was on both sides. Private also, government also.
Yes.
I know both sides.
And my lord, I will, my lord, humble prayer, my lord, when making submission on behalf of my client, my lord, my learned friend should only
I am
listen.
not allowing. I am not allowing.
Interrupt.
I am not allowing that.
Yes.
I am not.
No,
but
he will say that the letter is not rely upon a document which has not been proved, and I will say and have lollipop.
No. The court is there.
At your chance, you will say.
No. You will say.
So
That is,
court is there.
Millet, just when he has raised this point, Millet, kindly, Millet, I'm sure Millet used to will look into the documents. He has said the that what report? This report, the scope of report was removed from our BOQ after it was handed over. The price which was allotted for us to get a report, it was struck off. And he's saying I can go and get report from my veranda. He has not gone through the documents.
It happens. Yes, come ready
Tomorrow.
Tomorrow you finish it.
Yes, my lord.
You will get 45 minutes.
Whatever the case of the Union of India has, I will place your lordship.
No, not. I am not telling that. See,
Yes.
with regard to if the private brief, you can tell your client anything and they will bring.
Yes.
For the
But in
government,
government, your lordship knows
very
very well.
difficult.
Government side, your
I
lordship
know.
had.
It is very
How
difficult.
much is supported by the department?
But no, not support. That's why you have to be strict in the department. If you are in the government of India, advocate for the government of India, you have to be a guts. Otherwise, you will be making fool of all the officers to you. So and so bring for the plaintiff, so and so bring for the defendant. The plaintiff has counsel for the defendant has argued the matter at length, but due to paucity of time, hearing could not be completed. Argument could not be completed. The matter is already fixed tomorrow at 3 p.m. Let the matter appear tomorrow at 3 p.m.
It is fixed at 3, my lord. Tomorrow it is
3 p.m. 3 p.m. Yes.
Problem.
Yeah, witness. Yes.
May it please your lordship. My lord, I appear for the plaintiff in this matter Your Lordships has fixed it today for conclusion of my examination in chief, my Lord. The
Witness
witness
present.
is here. Yes, my Lord. On the last occasion, my Lords, we had covered documents exhibiting from A to D. May I please continue, my Lords?
ঠিক আছে
With your Lordship's leave, my Lord.
Yes. Start.
Shown pages 226.
হ্যাঁ না
হ্যাঁ,
এর আগে হয়েছে বিদ্যুৎ চন্দ্র সেন
Examination chief continue. Resume.
226 to
Shown page 226 of the judge's brief document. Judge's brief থেকে দেখি তো একটাই জিনিস, এটা অরিজিনাল আছে। হ্যাঁ, ঠিক আছে। What is this document?
এই ডকুমেন্টটা কি
This is a ledger.
দিস ইজ এ লেজার
Who has issued this document?
Plaintiff has issued the document.
What does this ledger enumerate?
এখানে প্লেন্টিভ যে সেলস করেছিল এবং মেটেরিয়াল সেলস এবং মেশিনের পর যে রেন্ট করেছিল সেটা রেজ করেছে বিলগুলো এবং এটা আরেকটা হ্যাঁ
the plaintiff has raised bill regarding the sales and the rent তারপরে
এবং সেখানে ডিফেন্ডেন্ট যে ডিফেন্ডেন্টের যে আউটস্ট্যান্ডিং আছে সেটা শো করছে
and this document also shows the outstanding amount of the defendant
Outstanding amount against the defendant.
What is the period for which this ledger has been drawn up?
Period 3rd July 2019 to 30th August 2021.
Is page 226 of the judge's brief. I will just look at it.
তোর কাছে লেজার
I will take it. আগে 226 ওর পরে 27 and 28 দুটো লেজার আছে। আগেটা 226 জিজ্ঞেস করছি, ওর পরে
3rd July 2029 sorry 19
এর কোশ্চেনের উত্তরটা দিচ্ছে
3rd July 2019 to March 20.
Very well. Shown pages 227 to 228 of the judge's brief. Sorry. Before going to that, how have you come in possession of this document?
226
হ্যাঁ এই ডকুমেন্টটা আমি প্লেন্টিফের রেকর্ড থেকে প্লেন্টিফের যে ডাইরেক্টর আছে সঞ্জয় কুমার ডালমিয়ার প্রেজেন্স থেকে আমি নিয়েছি।
I have obtained this document from the records of the plaintiff, Mr. Sanjay Kumar
ডালমিয়া
Are the
director
of the company.
Are the contents of this document true and correct?
yes
বলবো?
হ্যাঁ।
Shown pages 227 to 228 of the judge's brief document.
728.
What is this document?
This is the ledger.
Who has issued this ledger?
Plaintiff has issued the
Ledger.
What does this ledger enumerate?
এখানে দেখাচ্ছে যে প্লেন্টিভ যে সমস্ত সেলস বিল রাইজ করেছিল এবং রেন্টের বিল রেজ করেছে এবং আউটস্ট্যান্ডিং অ্যামাউন্ট দেখাচ্ছে শো করছে।
This ledger shows the sales and the rents that he had
raised against the defendant and the outstanding
Outstanding
amount
amount.
against the defendant.
How have you obtained a copy of this document?
Plaintiff's books and records থেকে in the presence of the plaintiff director Mr. Sanjay Kumar Dalmiaর presence আমি
I have
রেকর্ডটা পেয়েছি।
obtained this document from the books and records of the plaintiff company in presence of its director, Mr.
Sanjay Kumar Dalmia.
Have these ledgers been prepared under your supervision?
Yes.
For what period has this ledger been drawn up?
এখানে
1st April 2019 to 30th August 2021.
Are the contents of this ledger true and correct?
Yes.
My lords, both the ledgers could collectively be exhibited as E, my lord.
E collectively.
Shown page 229 to 231 of the judge's brief of document. 229 to 231, 231 of the judge's brief of document. What is this document?
এটা ব্যাংকার সার্টিফিকেট আছে যেখানে ব্যাংকার সার্টিফিকেট।
This is a certificate issued by the bank.
Which bank has issued this certificate and for what purpose?
ICICI Bank has issued this certificate. ICICI Bank
has issued this certificate.
হ্যাঁ, এখানে এটাই লিখছে যে আমরা ওর কাছ মানে ব্যাংকের থ্রু 15 লাখ টাকাই পেয়েছি
This
আজ
certificate
অবধি।
states that আমরা
মানে প্লেন্টিফ
the plaintiff company has received only rupees 15 lakhs from the defendant till date.
Shown page 230.
230 is the bank statement.
প্রশ্নটা জিজ্ঞেস করুন। What is the period towards which the bank statement has been issued by the said ICICI Bank?
1st March 2021 to 30th March 2021. No, 30th March 2021.
Can you, from this bank statement, identify the transaction, identify the payment that has been made by the defendant in favor of the plaintiff? In favor of the plaintiff.
30th March 2021, 15 lakhs has received.
On 30th March has been received by the plaintiff.
How have you obtained this document?
এই ডকুমেন্টটা আমি ব্যাংকে গিয়ে ব্যাংকারের কাছ থেকে আমি নিজে গিয়ে নিয়ে এসেছি এটা।
I have obtained this document by personally visiting the bank and obtaining it from the bank official.
Who has signed this document on behalf of ICICI Bank?
Relationship Manager Sumit Samanto of ICICI Bank.
Has such signature been appended by the said Sumit Samanto in your presence?
Yes, আমার সামনেই সই করেছে।
Yes, he had signed in my presence.
Are the contents of this document true and correct?
Yes.
May the bank statement be exhibited as Exhibit F. Shown page 232 of the judge's brief of document. 232 to 234 করে দিন।
এখান থেকে দেখতে পাবেন 232 to 234.
What are these documents?
This is a ledger.
These are ledgers.
Confirmation by defendant.
Ledger confirmation by the defendant.
For what period does this ledger pertain to?
3rd July 2019 to 24th March 2021.
I am drawing your specific attention to the bottom of page 232. Who has signed this document?
Dependent Harpal Singh has signed this document in the presence of me and director Sanjay Kumar Dalmia.
Has signed this document in my presence and in the presence of Mr. Sanjay Kumar Dalmia, our director.
Why did the defendant sign this document?
ডিফেন্ডেন্ট এটা লেজারটা দেখে উনি স্যাটিসফাইড হয়েছিলেন এবং আমাদের সঙ্গে মিলে উনি বলেছিলেন এটা ঠিক আছে, দ্যাট ইজ ওকে, এই কারণে উনি সাইন করেছিলেন।
After going through the document, the defendant was satisfied and thereafter he put his signature on this document.
How did you come in possession of this document?
এটা আমাদের বুকস অফ রেকর্ডস থেকেই এই ডকুমেন্টটা নেওয়া হয়েছিল।
I obtained this document from the books and records of our company. আপনার ফোন বাজছে?
না না।
Are the purport and contents of this document at page 232 of the judge's brief true and correct?
Yes.
Shown pages 233 and 234.
233 and 234
of the judge's brief of document. What is this document?
233 and 234 also the confirmation ledger which is confirmed by defendant.
Was confirmed by the defendant.
Who has drawn this ledger and for what period?
Plaintiff drawn this ledger and from the period is 1st April 2020 to 24th March 2021.
I am drawing your attention to the bottom of page 234 of the judge's brief of document, where a signature appears. Who has signed this document?
Defendant Harpal Singh has signed this document.
Harpal Singh.
Has this document been signed by the defendant in your presence?
Yes. My presence and also my director, that is plaintiff's director Sanjay Kumar Dalmia, in the presence of both.
Where has this document been signed by the defendant?
At our office.
In your presence and in the presence of the plaintiff's director?
At our office, that is plaintiff's office.
That is the plaintiff company's office.
Could you please provide the details of the address at which the said ledger has been signed by the defendant?
130 Cotton Street, Kolkata 7. Cotton Street, Kolkata 7.
130, Cotton Street, Kolkata 7000007.
How have you come in possession of this ledger at page 233 to 234 of the judge's brief of document?
এটা আমাদের বুকস এন্ড রেকর্ডস এর থেকে in the presence of plaintiff's director Sanjay Kumar Dalmia's presence এটা নেওয়া হয়েছে।
I obtained this document from the books and records of the company in the presence of the director Mr. Sanjay Kumar Dalmia.
Are the purport and contents of the ledger appearing at pages 233 to 234 of the judge's brief of document true and correct?
Yes, true.
My lord, both the ledgers be collectively marked as
G.
Exhibit G, my lord.
G collectively.
Shown page 235 of the judge's brief of document. Now. What is this document?
This is the mail communication.
Who has issued this mail communication and to whom is this mail communication addressed?
আমি এটা ইস্যু করেছিলাম
I had issued this mail
ডিফেন্ডেন্টকে।
to the defendant.
What are the purport and contents of this document?
এখানে কন্টেন্ট আছে যে আউটস্ট্যান্ডিং যে পেমেন্ট ছিল সেই পেমেন্টটা রিমাইন্ডার দেওয়ার জন্য
The content of
ডিফেন্ডেন্টকে
this
করা
mail
হয়েছিল।
is বলুন কি লিখেছেন?
এখানে আউটস্ট্যান্ডিং পেমেন্ট যেটা ছিল সেটা রিমাইন্ডার এবং তাকে
Mail was for the reminder of the
for outstanding
outstanding
payment.
payment of the defendant.
Also second, আচ্ছা
Can you identify the mail ID from which such mail was issued?
mail ID headoffice@jalnidhi.com. This is our official mail address. This is plaintiff's official mail address. headoffice@jalnidhi.com.
And this is our official mail address.
Do you have access to the email ID headoffice@jalnidhi.com?
Yes.
Where have you sent this email from?
ওদেরকে ইমেলটা পাঠিয়ে
এই মেলটা আমাদের অফিস থেকে অফিসিয়াল মেল থেকে এটা পাঠানো হয়েছিল এবং আমি
I had
পাঠিয়েছিলাম
sent this mail from our official
মেল অ্যাড্রেস।
from our office.
How have you obtained a copy of the said email?
এই মেল আমি আমাদের সিস্টেম থেকে লগ ইন করে জেনারেট করা হয়েছে, প্রিন্ট আউট নেওয়া হয়েছে।
I had taken the printout of this mail after I logged into the system and generated this document.
What is the date on which the said mail has been issued by the plaintiff?
2nd July 2022.
Are the contents of this document true and correct?
Yes.
Shown page 236 of the judge's brief of document. What is this document?
এটা একটা মেল করা হয়েছিল আউটস্ট্যান্ডিং পেমেন্ট উইথ ইন্টারেস্ট ক্যালকুলেশন করে তাকে প্লেন্টিভ মেল করেছিল ডিফেন্ডেন্টকে।
This is a mail that was issued for the issued to the defendant for the reminder of the outstanding along with his interest.
Who issued the said mail on behalf of the plaintiff company?
কে issue করেছিল?
আমি ইস্যু করেছিলাম প্লেন্টিফের মেল অ্যাড্রেস থেকে
I had
ডিফেন্ডেন্টকে।
issued the mail from the plaintiff's mail address to the defendant.
When did you issue the said email?
কবে করেছিল?
23rd December 2023.
Which ID did you use to issue the said email dated 23rd December 2023?
headoffice@jalnidhi.com.
Which email ID was addressed to as a recipient to this for this email?
Mail address.
harpal1963@readymail.com.
Harpal 1963@rediffmail.com.
How are you in possession of this document, of this email?
এটা আমি সিস্টেম থেকে লগ ইন করে এই মেলটাকে প্রিন্ট আউট করা হয়েছে।
After I logged into the system, thereafter I printed it from there.
Downloaded and printed it from there.
Is the system that you're referring to situated at the registered office of the plaintiff company?
Yes.
Are the contents of this email dated 23rd December 2023 true and correct?
Yes.
Right. Both these emails be kindly exhibited as Exhibit H.
H collectively.
Shown pages 237 to 238 of the judge's brief of document. What is this document?
This is the calculation statement for interest.
Who has issued this document?
I issued this document. I issued this document, and also my instruction, our accountant has prepared this document.
I issued this document and my accountant has prepared this document on my instruction.
What does this document enumerate?
এই document কি বলছে?
এই ডকুমেন্টে বলছে যে এখানে ইন্টারেস্ট ক্যালকুলেশন করা হয়েছে at the rate of 18% and interest হ্যাঁ 15 lakh 1,38,094 to 743 is the principal amount, and 81 lakhs 27,729 is the interest.
This document enumerates the principal along with 18% interest. The principal is
Principal amount is 1,38 lakhs 94,743. And interest amount 81 lakhs 27,729. That is total amount 2 crores 20 lakhs 22,472.
the total amount.
Who is liable to pay the said outstanding sum of
Defendant
rupees
Harpal,
2 crore 20 lakhs 22,472?
Defendant Harpal Singh.
What is the period for which this What is the period for which this tabular statement calculating the outstanding dues has been made by the plaintiff?
3rd July 2019 to 11th June 2021.
How have you obtained a copy of this document?
From our books and records. That is plaintiff's books and records.
Has this document been prepared under your supervision?
Yes, my supervision.
Are the purport and contents of this document true and correct?
Yes.
Raj, the same be exhibited as Exhibit I.
Yes, next.
Shown page 239 of the judge's brief of document. What is this document?
এটা সুট ফাইল করার আগে মেডিয়েশনের জন্য ডিফেন্ডেন্টকে জানানো হয়েছিল, কিন্তু ডিফেন্ডেন্ট আসেনি।
This is the document that we had sent to the defendant.
This is a non-starter report issued by the mediation center. Yes, next.
When has this document been issued?
Not necessary.
Not necessary. May I just mark this as exhibit? Exhibit J ho jabe eta. Shown page 240 of the judge's brief of document. What is this document?
এটা একটা সার্টিফিকেট যেটাতে বলা আছে যে আমরা ডিপেন্ডেন্টকে ইয়ে করা সত্ত্বেও ডিপেন্ডেন্ট অ্যাপিয়ার হয়নি জানা সত্ত্বেও। অ্যাপিয়ার হয়নি তার সার্টিফিকেট।
This is a certificate that says that the defendant has not entered appearance in the suit.
Who has issued this document?
ডেপুটি রেজিস্ট্রার লিগাল। Yes, sir.
Can you identify the signature appearing at the bottom of this document?
Yes.
No, it will not.
Yes, right.
How have you obtained a copy of this document? How have you obtained this document?
এটা আমি আমাদের অ্যাডভোকেট এস কাকরানি অ্যান্ড কোম্পানির অফিস থেকে বুকস অ্যান্ড রেকর্ডস থেকে এবং ইন দ্য প্রেজেন্স অফ দ্য মিস্টার কাকরানিয়া আমি ডকুমেন্টটা পেয়েছি।
I have obtained this document from the learned advocates S. Kakranias.
No. My learned advocate had applied for the certificate from the department. Yes.
No, he can't prove this document is true and correct because he's not signed it, so I'm not asking that question. That's the sum and substance of all the exhibits, my lord. So grateful. This be marked as exhibit,
Exhibit.
just the last one, as K, exhibit K. Yeah.
Yes, next.
My lord, that's
That's
all.
all.
Throughout the document. So grateful.
Suffering for the plaintiff.
My lord, also, your lordship will kindly have my section 63 affidavit that is there. Your lordship's record.
Plaintiff witness is present. Examination chief is resumed. During the examination, documents being exhibit E to K. We are marked as exhibit. Counsel for the plaintiff has filed affidavit
Under section 63,
under section 63E.
Yes.
Only 63.
only 63, my lord.
63 of the what?
Bharatiya
Nyaya Sanhita.
Nyaya Adhiniyam.
Bharatiya Nyaya Sanhita 2020. Let the same be kept with the record.
Well, just one more thing. His board resolution authorizing him to depose before your lordship. Although I have exhibited this document
But-
and the board, if your lordship wants for abundant caution.
रख दो file में रख।
हाँ, just for your lordship's record.
Affidavit of competency of the witness filed by the plaintiff be kept with the record. Plaintiff witness is closed. Closed. Full counsel for the plaintiff submitted that he will not close and witness is discharged. The witness examination is closed and discharged. Okay. Counsel for the plaintiff submitted that he will not adduce any further evidence. Accordingly, evidence on behalf of the plaintiff is closed. Please the matter. When? After vacation?
Subject to your lordship's convenience, my lord. I'm at your lordship's
This is the
disposal.
matter on 11th June for argument.
I'm so grateful.
Thank you. Next.
No, I'm for the defendant.
Anybody else? Who is for the plaintiff?
I don't know, my lord.
Rajgaria.
The application, my lord, for attachment before judgment, my lord will see the last order, my lord. I was not changed brief. And, we have not filed our written statement.
Which one? GA2?
No,
GA4?
GA1 is, my lord, pending, which is attachment before judgment. But my lord will see the last order, it is 16th of December, my lord. The change brief, my lord. My lord records that since we have not filed our written statement,
And they filed and thus the prayer for and just prayed for fixing the matter in the list for the undefendant list.
My lord, I have been informed by the
Concept and
Counsel of
defense
the
submitted 90
plaintiff
days, 90 days
to pass it over.
matter to mediation for settlement. There is very chance.
Hold on. pass over. जी sir.
No, और आगे और पता है.
Yes.
So, well, I do not know what is the stand of the plaintiff as of now on CIRP, and the well, anyway the application has to be heard. This matter was lingering. In
Yes. After
The counsel of the plaintiff has informed me that he
so
is
you are in CIRP, how the suit can proceed?
No, I am not. They are the plaintiff.
That's I'm telling. Who is in CIRP?
Plaintiff.
Then how the suit will proceed? You are in CIRP. How the suit will proceed?
I am not aware of the fact of the suit, but I have been informed by the counsel of the plaintiff that for praying for a short Passover.
Passover, where is the time? So suffering for the plaintiff.
10 minutes Passover.
So suffering for the defendant. Counsel for the plaintiff prays for adjournment. According to case adjourned, let the matter appear on 17 June 2020.
Okay.
Next.
May I take Malar's 1 minute? I've been following suits in commercial division. In commercial division, when affidavit in chief is filed, all documents are to be explained in the affidavit in chief. So this rigmarole of
why that is correct. What is happening? You are examining. You are explaining the document and bringing an exhibit A, B, C, D. But sometimes what's happened? How the document will identify? Exhibit.
All those have to be written in the chief. Only the.
But what happens? Some of the advocate.
I understand.
The Xerox will.
That is the problem. But so much time is wasted, my lord, on that. Because everything is written, that how I got the documents, how I received the documents.
That is not necessary. It is undefined I have taken.
I understand.
It is undefined I have taken. Otherwise, if it is a contested suit, only the original has to be shown
and marked. And everything has to be explained in the.
No. Yes, everything is to be explained. Only the original is to be shown from the giving the reference of the JBD. That's all.
I understand. But I've been seeing.
No, this is only because the undefined.
I understand.
Okay.
Well,
thank you.
Number 17.
I am for the defendant led by Rajoshi Datta. I am for the defendant led by Rajoshi Datta. I am praying for short Passover, my lord. He is on his legs, my lord.
Short. If concluded, who is for the plaintiff?
Plaintiff has concluded.
Yes, you are.
I am praying for short Passover, my lord.
There is nothing in this, Mr. Datta knows. So suffering for the plaintiff, suffering for the defendant. Counsel for the defendant prays for time. According to case adjourned, let the matter appear on 29th April. Next.
Grateful, madam.
My lord, I am for the defendant. My lord, I am for the defendant, my lord.
I pray for the plaintiff.
My lord, there are 3 applications, my lord, appearing in the board, my lord. 3 applications filed by application by the plaintiff, that is GA number 1, 2, and 3. And my lord, 4, 5, and 6, my lord, filed by me, my lord, defendant. My lord, so far the GA6 is concerned, my lord. This is an application for addition of party. Your lordship may recall, my lord, this is the matter, my lord, group of companies, my lord, a company of Netherlands, my lord. I was making submissions as regards to my application for referring the dispute to arbitration in terms of the distributorship agreement, my lord. My lord, GA6 is for addition of party.
Where is the GA6?
GA6, may I file my opposition? I was out of time.
Filed.
May I file? I had served, but they have also served us with their reply.
Reply, my lord.
Yes. GA6 for addition of party.
Yes, my
and
lord.
GA5?
GA5 and 4, my lord, are yes.
Section 8.
Section 8. GA5 is only as
GA1 is the interim application. GA3 is an application for judgment on admission. And thereafter, GA4 was an application under Section 8. GA5 was an application for production of the arbitration agreement. And GA6 is now for addition of party. GA2 perhaps was moved before the department for extension of time to file lodge writ of summons.
Yes.
But there is an interim order which is subsisting.
Yes.
Milord,
What about the GA6?
yes, Milord, I can address your lordship. Yes, Milord.
Ready?
Yes,
Milord, kindly take GA6, Milord.
Yes.
Milord, I will not take your lordship, my lord, to the correspondences, Milord, because, Milord, in the earlier, in my GA3,
What is the opposition?
Opposition, my lord, principally on two grounds. I have sought addition of party as co-plaintiff. That this is the principal ground taken by my learned friend on the principal dominus litis. And the second is there is no concluded contract.
I'll indicate that is not the principal ground, but that's a point of maintainability that I have taken.
Yes.
But even on merits, I'm ready to argue.
Yes.
Okay.
Milord, kindly, I am straight away, Milord, taking your lordship. My lord, the reason, my lord, why I am seeking addition of party, my lord. Your lordship may come to paragraph 10. May consider paragraph 10, 12 and 13 of my application. Yes. Your lordship, defendant number 10, paragraph 10, the defendant states and submits that the purchase orders, invoices, e-way bills, delivery notes placed and or reference made in the plaint thereof form subject matter of the aforesaid distributorship agreement. Next, paragraph 11. Moreover, in terms of the above contract, the plaintiff hereof is not entitled to claim and or recover money from the defendant, and it is Flint, Netherlands can claim it. My lord, I will show from the agreement. My lord, it is only Flint, Netherlands can claim money, not the plaintiff here. Now, my lord.
You filed an application for adding as a plaintiff.
Yes, my lord. My lord, I have a reasons to pray for you. Although, my lord, I will make alternative argument also, your lordship, my lord. Since records are before your lordship, my lord, and
how the defendant can say he should be added as a party?
My lord, for two reasons, my lord.
No, how you can?
My lord, my humble submission, my lord, under order 1, rule 10, my lord. Based on the ingredients placed before the honorable court, my lord, either defendant or plaintiff can be added as a party.
Plaintiff can be added,
yes,
but on the basis on the defendant how the defendant can say he should be added as a plaintiff?
My lord, because of the reason, because here there is a money claim against me.
Maybe
there is a money claim. Plaintiff.
It is his claim.
Yes.
So how you can say no? He cannot claim.
No,
I am to be claimed. B is an necessary party. Should be.
I am not saying why I sought the Netherlands company to be added as a plaintiff, because of the two reasons, my lord. First, because the contract provides that which I am relying upon. The distributorship agreement says that the Netherlands can only seek money.
Correct.
Now, second, my lord, in terms of section 21 notice I have served, I have disclosed this notice in my application, my lord, where I have made a counter claim
against
the principal company, but
21 application you have made a counter claim. What's
no, in section 21 notice I have made a claim against the
I'll indicate.
I
After
made
this
a
application under section 8 was taken out, But it fell from your lordship during the course of arguments that the defendant has not taken out any application for addition, and thereafter when this application was taken out, GA6. Before taking out this application, they served us with a notice invoking
21.
arbitration clause, alleged arbitration clause. That is what my learned friend is referring to.
Yes.
When in the main suit, the written statement has not been filed, it has already been marked as an undefended suit. And this is
No,
also
no,
one of
not
the
yet
things.
undefended suit, my lord,
Absolutely,
for
you're
two
not-
reasons, my lord. Because
It has
my lord,
recorded in the order, lordship.
my lord,
It's been
definitely,
passed
my lord,
upon.
I will address the issue of WS only. My lord, in the objection, it has been taken a point that I have not filed WS. My lord, I have filed this application, my lord, demurrer application, and seeking referring the disputes to the arbitration, my lord, within time. This is number one. My lord, the Arbitration Act says, my lord, once if I file WS, then I forego my right. I do not have any right to seek referring the dispute to arbitration. So I cannot file my WS because my right will go. Then if I file WS, then I submit to the jurisdiction of this, to the suit. So my lord, this reason, my lord, I have WS was not filed.
Okay, okay, continue.
Now, my lord, kindly take paragraph 12. I have referred the section 21 notice, my lord. It was served. Notice was not responded by any of the party. I have served notice to the plaintiff as well as the foreign company.
How many days over? 30 days over?
My lord, I think so, my lord. May I just, my lord, the notice
They have
6th
responded
March.
They have responded to this notice.
Okay.
My lord, it was served on 6th March. It was sent on 6th March by post, my lord. Yes.
Yes.
Now, my
next.
lord, at paragraph 13, my lord, I have stated the reasons. My lord, the subject matter of the 13.1, the subject matter of the present dispute directly emanates from the distributor agreement between Flint, Netherlands and the defendant. Flint, Netherlands' presence is necessary to comprehensively determine the real matter in dispute. Next, the addition of Flint, Netherlands is necessary to enable this honorable court to effectually and completely adjudicate upon and settle all questions involved in the suit. Third, the plaintiff, as a selling affiliate of Flint, Netherlands, is bound by the terms of the distributor agreement. Flint, Netherlands' involvement is indispensable to accurately ascertain the nature of obligations and liabilities under the said agreement. For the plaintiff and Flint, Netherlands are part of global Flint group. Given this corporate structure and the interdependent relationship, the plaintiff's claim is inherently linked to Flint, Netherlands. Next, furthermore, multiple correspondences between the parties corroborate the existence and enforceability of the agreement, including emails dated 9th or so-and-so emails. Now, my lord, here, my lord, I want to show, my lord, only one document because the plaintiff here as a threshold said that the contract was not concluded, but the relationship with the Flint, Netherlands has not been denied. The relationship with the foreign companies, the original company, my lord, who operates the business belongs to the USA. Now this company operates business in several countries through the other group of companies. Now, my lord, may I take your lordship's attention, my lord, to one document. One document. Kindly come to Lord, kindly come to page 13 of my application.
Yes.
Lord, this is the official website of the Flint Group company. My lord, kindly see at the top. Headquarters is in Jersey. My lord, left side. Now, my lord, kindly come to the next page, 14. My lord, kindly see operating facilities. The company operates more than 125 countries in North, Central, and South America, Europe, Middle East, Africa, Australia, New Zealand, India, and the
Pacific Rim.
Yes. Now, my lord, here, my lord, kindly see key personnel names are there. There are few names. My lord, kindly see there is one name at the bottom, Michael Finn, Chief Digital Officer.
Correct.
Now, my lord, I will show from the email correspondences that he was one of the party in the email correspondences. My lord, while when the that distributorship agreement was.
To whom you want to make the party?
My lord, I want my lord Flint, Netherlands, with whom I had a contract.
Where is that?
Flint, Netherlands. My lord, kindly come to
the Flint group print.
Yes.
Supply.
Kindly take my prayer.
Okay.
Yes. In the prayer I have.
Next.
Yes. Because I had a contract with Flint, Netherlands. And there was a contract that the supply will be made with, by the company, by the plaintiff company.
By the?
By the plaintiff company.
Who?
To me. I was a distributor to sell the products of the Flint group in the territory of West Bengal. And the plaintiff is a Gujarat-based company. He will supply, the materials will be supplied through plaintiff. This was the contract. And now, my lord, there is one more thing. There was a prior contract I had directly with the plaintiff company. There I was not a distributor. I was a clearing and forwarding agent working on percentage. This arrangement was it was
that all the things are okay. You have submitted. I have taken. I understand.
Yes.
How you can, because you can pray for so and so made as a party. How you can say? Defendant can say he should be made as a party. If okay, if on your basis the court will allow, and he is not coming forward, who will affirm the plaint? If suppose on your submission, on your application, this court allows your application, adding is a plaintiff, and he is not coming forward.
These are the technical.
Not technical.
This is
you are not understanding. You file the application. While preparing an application, filing an application, you are not ascertain what would be the fate of this application.
My lord, what my humble submission before your lordship, my lord. My understanding was that based on the record and the nature of the contract I had with the contract, because I had.
That is different.
That is different issue, my lord.
That is second aspect.
That is.
If your application is maintainable, then the second aspect, whether he is a necessary party or not. Now you being a defendant, you file an application, he is the necessary party. Till that it's okay. But he is the necessary party as a plaintiff, and he should be added as a plaintiff. How it can be? If that party is not interested to proceed with the matter, not wanted to go with any litigation, so how you can press upon him, put pressure upon him? No, you come and add as a party and file a case against me.
My lord, for that purpose, my lord, I will be relying upon few case laws, my lord, where, my lord, the co-plaintiffs were added, my lord.
Plaintiffs can be added. I am not telling the plaintiff
Yes.
cannot be. Plaintiff file an application. Plaintiff file an application. He should be added. Transposition. All the things is if the plaintiff also can file an application for transposition on the one of the defendant as a plaintiff. There's no bar. But show me the law.
Yes.
The defendant can file an application for adding as a party to a third party, not he himself.
My lord, there is one case law I found, my lord, that is reported, my lord, in 1994, my lord, Madhya Pradesh, my lord, 1994 reported, AIR reported judgment, my lord, where the defendant, my lord, took out an application, my lord, and sought an addition of co-plaintiff, my lord, and and it was allowed, my lord. This is the only judgment I found, my lord. I will place it, your lordship, my lord. But my lord, my alternative argument also will be, my lord.
What?
My lord, the alternative argument is yes. My prayer I have made, I sought for a co-plaintiff, but this is, your lordship has a judicial discretion, my lord. My lord, the order 1 rule 10, my lord, this is a substantive right, my lord.
That is court suo motu or an application. Once an application is been filed, the
Yes.
court suo motu now cannot change the alter the prayer.
No, my lord, I will try to satisfy your lordship, my lord, on this aspect also. So far the order 1 rule 10 is concerned, your lordship can always exercise of, this is a judicial discretion, my lord can exercise it for complete adjudication of the matter. My lord, this is the alternative argument I will make, my lord. This is the alternative because my the last prayer, any further order or any orders in the interest of justice can be passed, my lord. My lord, that issue is there. My lord, kindly allow me, my lord. Your lordship will consider that. My lord, I want to show one document. My lord, I am not taking your lordship, my lord,
For what?
to entire correspondences. To show
That's
the next.
telling that is the secondary issue. First,
show
you
the
have to
nexus.
satisfy this. First, you have to satisfy with regard to the how your application is maintainable for bringing a third party has to be added as a plaintiff.
My lord, I have the judgment, but my lord,
Show me what is the judgment. Show me.
Physical copy, my lord.
Show.
Or your lordship, my lord, kindly keep it tomorrow, my lord. I will bring the copy
Every
of it.
time you can.
No, my lord, I have worked out in the brief, my
No
lord.
problem. I will go from your laptop and no problem.
I have made a marking in my brief, my lord. Very well.
Give the citation. What is the citation? I will call.
My lord.
Give the citation.
Lord, I am showing, my lord. These are the case laws, my lord. I have gone through, my lord. I have gone through what I am seeking, my lord. Kindly give me. I could not take the print out, my lord, because the learned advocate on record, my lord, had some personal difficulty, my lord.
So you are believing upon the head notes and you're preparing.
No, not head note, my lord. I don't read head note. I don't read. I have gone through the judgment, my lord. After reading the opposition, my lord, my lord, on my level, my lord, I have tried to. I have done all preparation, my lord, to meet these.
Tell me seriously, seriously to this court.
Yes.
You're seriously contesting the suit, or seriously you're making mockery of.
No, my lord, I'm not.
Or
I'm
mockery
not
of the
making.
proceedings.
My lord, what is
because
my?
Initially you filed an application under Order 8,
Yes.
under Section 8.
Yes.
The court is of the view under Section 8 is not applicable. The main contractor is not here. How
Yes.
the subcontractor will come, if at all? How it can be without the making a main contractor as a party, main party to the contract as a party to the suit. Now he come with an application. He should be made as a plaintiff, and he is not before this court.
My lord, here the case is that the person who is the third party, my lord, is not a subcontractor.
He is the main.
He's the main.
That's I'm telling you. This subcontractor has filed the case against you.
Yes.
Now you have made an application under Section 8.
Yes, my lord.
Referring to the arbitration.
My
but
lord.
main agreement is with the Netherlands.
Yes,
He's
correct.
not a party. How the court can Section 8 can be allowed?
My lord, this is what, my lord, it was fallen. My lord.
So now you come with an application. You come with an application of opposite. Okay, I am allowing Order 12 rules say judgment upon admission. You challenge all orders, so that the burden can.
My lord, may I place my application, my lord? Your lordship will.
I am hearing you. Tell me. I am not going in your merit. First, you satisfied with regard to the maintainability of the application. How the defendant can file an application making the third party as a plaintiff?
My lord, may I place, my lord, order one rule 10?
Yes.
Yes.
Show me authority, show me law. If suppose the court allows your application and he is not coming forward, what would be the fate? Can your Section 8 application will be taken up? Whether his injunction application will be taken up? What? Then again the zero. If this court allow your application, addition of the party as a plaintiff to the third party, and this court allows, so who will come and file an affidavit? You.
My lord, kindly appreciate one thing, my lord.
Or the existing plaintiff will issue the notice to the added plaintiff.
Kindly appreciate one thing, my lord. I will show it from the materials of record, my lord. May I just submit. Here the plaintiff, my whole case is the plaintiff has not approached this court, my lord, with clean hands. First of all, I did not have any direct relationship with the plaintiff. Plaintiff is merely a
So why Section 8?
Mediator.
So how Section 8?
Section 8, my lord, because in terms of the contract and the transactions form subject matter of the suit relates to the contract.
Contract with whom?
With a foreign company.
Then?
And these are group of companies.
Then?
These are group of companies. Now, your lordship, kindly, if you look at the plaint, what is the it is just cleverly drafted. What the plaint says, that purchase order received by me, goods supplied, these are the invoices. These are the only 3 documents. There is no averment how the contract established by and between the parties. Nothing has been disclosed. In my application, I have disclosed. Your lordship will see there is a document which was terminated by the plaintiff. My lord, it was 2018.
That is the problem, sir. He filed the suit.
Yes.
Along with the GA1. Correct. Now he also filed an application for judgment upon admission. What you have filed? What you have filed? You have filed Section 8 application. Filed Section 8 application. So, if the Section 8 application is there, whether this court can go with the order judgment, summary judgment, that your application is to be decided. So, during your application, you filed an application for addition of party. Now, in the addition of party, you being the defendant, you prayed for addition of the plaintiff. So I will take your Section 8 and this application together. Are you?
My lord, may.
If you're not understanding, what can be done?
My lord, kindly take order 1 rule 10, my lord.
Yes.
My lord, I'm referring sub rule 2. Court may strike out or add party. The court may at any stage of the proceedings, either upon or without the application of either party, and on such terms as may appear to the court to be just, ordered that the name of any party improperly joined, whether as plaintiff or defendant, be struck out, and that the name of any person who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon the settle all the questions involved in the suit. So, my lord, here, my lord, I want to draw your lordship's attention, my lord, on 2 aspects. Here, kindly, the first party's name can be struck out either by way of formal application or suo motu. Now, second part, that the name of any person who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon all the questions involved in the suit, be added. So, for the purpose of addition, my lord, that discretion is also with the
Court.
with your lordship, my lord.
Correct.
And my lord, this is a judicial discretion.
Correct.
Because, my lord, this is the appealable order. So, my
Correct.
humble submission, this is a substantive right given to the parties. And the court, on the other hand, suo motu, based on the record, materials on record, can also be done. Now, my lord, in this context, my lord, may I just one document, my lord? I will not take your lordship, my lord, to the whole communications. There is only one document, my lord. I have shown from the official website of Flint Group, my lord. That is at page
14.
Yes, my lord. It starts from
13 and 14.
Yes, page 14. My lord, kindly see at the bottom, Michael Finn, Chief Digital Officer.
Yes.
Now, my lord, kindly come to the email correspondence, my lord, at page 59 once. Kindly see at the middle.
Yes.
Kindly see at the middle, my lord, some Vera Abramova, my lord, sent email, dealers without contract.
Yes.
Now, my lord, kindly look at the CC. The second name, my lord, Michael Finn.
Correct.
Michael Finn.
Correct.
And my lord, on page number 60, your lordship will also find that that person's name is also appearing.
Yes.
Page 60 at the top right side.
Yes.
Yes. And my lord, kindly see, these are there are 3 named distributors. I was one of them. Number 1, SAS.
Where you're telling?
My lord, kindly come to page 60.
60 I'm there.
Yes, please find the response.
That's a size. Okay.
Yes. And kindly see the heading, dealers without contract. These are trail mail. Now, my lord, so in all in almost all material correspondences, this Michael Finn was a part of the correspondences. So the plaintiff cannot deny that he has no connection, and this is also a contention of the plaintiff in its opposition, that the plaintiff is a juristic entity and has no connection with the Flint Group of Netherlands.
That is not my
No, it is not the case.
No, it has been written in the opposition.
No, I have not stated.
So, my lord, if I take it, if they have not denied their relationship with the Flint Netherlands, and from the correspondences, if it is established that yes, I have signed the contract digitally, it was communicated to the foreign company, and in those correspondences, the plaintiff was a party to those communications. And my lord, one communication, my lord, I want to show, where in the communication, the plaintiff's officer disclosing the name of the Flint Netherlands, that I have to go by the contract of the Flint Netherlands. My lord, may I show only that correspondences. My lord, kindly come to my lord, it is appearing at page. Yes, my lord. Kindly come to page 19.
90.
Yeah, 19. Page 19. The email starts from page 18.
Yes.
Yes, my lord. Kindly see on 15th May, Amar Sen, page 18 at the bottom, my lord.
Yes.
Yes. From Amar Sen, this is the plaintiff's officer writing, issuing an email on 15th May 2020 to Sujoy Loda, that is the defendant. My lord, kindly see the body of the email correspondence, that is 19. Dear Sujoy ji, please refer below. Quote from CFO, which is repetition what we discussed earlier and today also. All distributor agreements are being centrally signed by Flint through Flint Netherlands only, and all dealings will happen with India. This is the company policy with no options. Also, please note that this is dealership agreement. We are run by Flint, which is a global footprint. So policy on appointing dealer to represent Flint, a global brand financial dealing, will be with India, but as policy and standard is global. So, my lord, my humble submission, my lord, here the plaintiff was also a part of the contract. In
That's
fact,
why. That's why on the last occasion also
yes, my
telling. Suppose he is the part of the contract. Without the main contractor has been made a party, how your application is maintainable?
so my lord, that is why, my lord, this application was
That's why
filed.
you made an application, but
Yes,
you made an application to making them as a plaintiff.
Lord, I will try to satisfy your
And
lordship.
on the second way, you also issued the notice under 21. Once you issued the under 21, so what is the remedy? Section 8.
No, section 8 was already filed.
You filed,
Yes.
but after
was a
filing, you
subsequent-
issued the section 21. After filing the section 8 application, you issued the notice under 21.
My lord, my humble submission, my lord, there is no bar, my lord, I can issue, because, my lord, there, my lord, I claimed against the Netherlands company. I suffered damages because of their action. Because of their action, I raised a claim. There I raised a claim.
Yes, next.
And, my lord, one clause, my lord, I want to show from the agreement, distributorship agreement, my lord. The distributorship agreement, my lord, I have a next. My lord, it starts from Lord, it starts from my lord, kindly come to page 53. Look, the contract starts from
Page
start from
53.
43. The contract start distributorship agreement, my lord, starts from page 43. At the
Yes.
top, your lordship will see, my lord, the doco sign ID, envelope ID is also there. Page 43 at the top.
Hmm.
The signing parties are, my lord, Flint, Netherlands, and the defendant. Now, my lord, kindly come to page 53 once.
Arbitration.
No, this is termination clause. Since I'm making argument of G6 for addition of party, my lord. Here, my lord, my lord, this is the reason, my lord, why I sought, my lord, co-plaintiff, my lord. My lord, kindly, may I please 11.6 once. Upon any termination or expiration of the agreement, Flint selling affiliate shall have the option to demand from distributor, and distributor shall comply therewith to return a part of the complete stock of the products purchased by distributor from Flint selling affiliate against payment of the originally charged price to the extent distributor has not affected any subsequent sales with regard to these products and does not need them from does not need for fulfilling warranty obligations. Flint selling affiliate must assert its claim for the return of products within 3 months after termination of this agreement. The cost and risk of the return shall be borne by Flint Selling's affiliate if the products are returned upon its request. So here the selling affiliate, my lord, if your lordship, my lord, considers the whole contract, what was the job of the plaintiff? He was a supplier only. I had a contract with Flint Netherlands, and even if the contract expires or terminated for whatever reasons, the plaintiff can only recover goods from me. He cannot recover money from me. Because the money recovery can be done only by the Flint Netherlands, not by the plaintiff. Now, my lord, in response to your lordship's query,
So you want that the Flint Netherlands come as a plaintiff and recover money from you? He cannot recover the money, so that Flint Netherlands come and
I don't deny, my lord. I don't deny that I do not have any. I did not take the goods. I even don't deny that yes, there is Flint Netherlands gets money from me. In response to the claim, my lord, as per the contract, my lord, since, my lord, I have not filed WS, and my lord, I cannot address on the merit. My lord, in section 21 notice, my lord, I have explained that what was your conduct, and because of your conduct, I suffered loss, monetary loss, and I'm entitled to recover from you.
So what is the reply of the Flint Netherlands?
No, Flint Netherlands did not respond. Flint Netherlands did not respond. It was the letter was issued to them. Now, my lord, from the correspondences and the materials of record, my lord, it is apparent that the Flint Netherlands and the plaintiff, my lord, acted together. They acted together. The plaintiff company was aware of the fact. So far, the contract provides plaintiff cannot seek recovery of money from me. He can only seek recovery of goods. The entitlement to recovery money is available with the Flint Netherlands only. And I also cannot claim damages against the plaintiff because I had a contract with the parent company. So, my lord, I can claim, I can maintain a claim against the parent company, not against the plaintiff. My lord, kindly take the opposition, affidavit in opposition, filed by the plaintiff.
What is the agreement between you and the plaintiff? Clearing and forwarding agent agreement?
Yes, that was terminated once I became distributor. My lord, that contract I have annexed.
That is terminated.
Yes, it is appearing from page 20.
Correct.
My lord, prior I became distributor, I have pleaded all this
Okay.
details, my lord,
Yes,
in my application.
What is the affidavit in opposition?
My lord, may I address that part also, because it has also a nexus. If your lordship, my lord, look at, my lord, when I was working as an agent in West of Bengal, my lord, the plaintiff entered into a formal agreement. My lord, that starts from page 20. My lord, this agreement, my lord.
When it is terminated?
Huh?
When it was terminated?
It was signed on 9th June 2014 and it was terminated in 2018.
Then, yes.
28. My lord, what I am submitting, my lord, it's a constant stand of the plaintiff that they do not have, there is no formal contract between me and the plaintiff, nor with the parent company. The claim raised in raised in the plaint based on the purchase order and goods supplied to me only. They said that I made a oral request, on good faith they supplied to the goods and they are liable to get it money. Now, my lord, while referring the clearing and forwarding agreement, my lord, that is appearing at page 21, my lord, this agreement was not denied by them. They said that it is not material for the suit.
Correct.
Here, my lord, I can show the nexus.
2018 it is
my lord, I can show the nexus, my lord. It is completely unbelievable. If the defendant, when working as an agent, there was a formal agreement entered by the parties, and when he will become a supplier where the crores of goods, my lord, supplied to me without having any contract. My lord, I put it this question to myself, my lord. This is completely unbelievable stand, my lord. A company of an international stature, my lord, who is using the same logo, same website of the parent company, my lord, claims, my lord, without any contract, without any formal agreement, they have supplied products to me, my lord, worth more than crores. My lord, my humble submission, my lord, the plaintiff, my lord, is not honest before your lordship, my lord.
Yes. Any further?
My lord, so far the pleadings are concerned, my lord, I will kindly take the opposition once, my lord, just to show 2 points. What is their objection?
Same objection which the court has raised here.
Yes, my lord. Yes, my lord. It's already for. I will show judgment tomorrow, my lord. Only few judgments, my lord, on the issue, my lord.
Keep it in mind with regard to the cost also.
Author.
Cost also.
May I have my lord?
Keep it in mind the cost also. Suffering for the plaintiff, suffering for the defendant has filed an application being G6 JCOM 6 of 2024, praying for addition of party. Counsel for the plaintiff and the defendant and the क्या बोला? Addition of party. Plaintiff has filed affidavit in opposition and Defendant has filed affidavit in reply. Let the same be kept with the record. Counsel for the defendant has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear tomorrow under the same heading.
Lordship is keeping it to.
Yes.
Well, may I seek only one?
Tomorrow.
Well, may I seek only one indulgence? Well,
Great.
this matter. Well, I am for the defendant who has filed a petition for amendment. Well, tomorrow I won't be available. Can it appear day after tomorrow?
Which one? 19?
19.
For the other side.
The other side is here.
Yes.
I'm for the thing. I have no problem if he again.
19 record kara. Census and suffering for the plaintiff, census and suffering for the defendant. You are for the defendant.
Yeah, I'm for the defendant.
As per the prayer made by the counsel for the defendant, the case adjourned. Let the matter appear on 25th.
May I have my lord's leave to mention for extension of interim order, my lord. The interim order is expiring today, my lord.
My lord, this is
Dalhousie Athletic Club matter, my lord.
Huh?
Dalhousie Athletic Club matter. It was fixed by my lord on 10th.
9th April.
10th April.
My
9th
lord,
April.
my lord,
9th
this is
April,
that election matter
Election
which your
matter.
lordship was hearing, my lord, the injunction application.
The injunction application.
My lord,
Complete, Mr.
my lord, your lordship had kept this matter fixed for 9th April 2025.
No,
My lord,
it
in
was-
the meanwhile, my lord, determination was changed. So, my lord, the party is under the impression that determination has gone to Justice Mukherjee. My lord, approached that honorable court. My lord, it transpired that your lordship had passed an order whereby the injunction application, it was mentioned, is heard in part. Therefore, his lordship Therefore, Justice Mukherjee was pleased to direct us to approach the regular bench. My lord, in the meanwhile, we've taken out an application seeking leave of this honorable court to conduct the AGM. My lord, your lordship remembers that Mr. Praneet Bagh was leading me in the matter. We had requested this honorable court to kindly grant us leave to ascertain what the members want with respect to the plaintiff, the position of the plaintiff. My lord, we've taken out an application which is IAGA 4. So, my lord, I was humbly praying that the injunction application be taken up and the GA 4, which is our application, seeking leave to conduct the SGM, be also taken up, my lord, on any particular date.
Any particular date, my lord. Please.
By which order it has kept parted?
It was parted on, my lord. My lord was pleased to keep the 8th February.
My lord, 8th February 2025.
5th February.
My lord,
It was my lord's order on 5th February 2025. My lord, please. Today. 10th. My lord, if my lord takes up the matter was fixed on 9th, this was the order by my lord, and the interim order was till 10th of February. 10th of April, my lord, 10th of April.
Only I am keeping the GA1, that's all.
My lord, GA4 is of some relevance, my lord, your lordship.
Only GA1 is a parted. Other matters, this court cannot take. Census and suffering for the plaintiff, census and suffering for the defendants. Counsel for the plaintiff submit that. The GA1 hoga. CS में GA1. Counsel for the plaintiff submit that this court has heard the GA1 in part. Naked. Counsel for the plaintiff, the interim order granted earlier is going to be expired today.
Today, my lord.
Is it going to expire today? Today and pays for extension of interest. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 8th May 2025 or until further order, whichever is earlier.
My lord, may I make one humble submission? My lord, we had presented IAGA 4. My lord, this has appeared in the list of Justice Mukherjee. My lord, directions were passed for affidavits, but his lordship on the next day, my lord, recalled his lordship's earlier order stating that that honorable court does not have jurisdiction and therefore this matter should go before the regular bench. So, my lord,
this is not the regular bench. Regular bench is the other bench. This is the commercial bench. Only I am taking GA1 because of the parted.
GA1 has been fixed by my lord as a parted matter, as marked as a parted
GA1
matter.
I am taking only as it is a parted.
Lord, but this is the same application under the same suit.
I can't do that. This court cannot. This court has only the parted matter or assigned matter. That's all. And otherwise, this court is not having a determination of the other matters unless.
My lord is fixing
other
the
than
matter.
the
GA1 any day, on a particular day.
Come on, 8th we'll see to that.
8th of May.
8th May.
The interim order is expiring tomorrow, my lord.
Tomorrow? Come tomorrow.
The order
Commercial matter?
Commercial.
Come tomorrow.